A panel of 5 justices of the Constitutional Court led by Justice Kenneth Kakulu and including Lady Justice Eleni Obura, Justice Stephen Musota, Justice Christopher Madrama, and Justice Remy Kasule ruled that the court-martial should not try civilians. In a majority decision, justices agreed that the General Court-Martial is not an independent and impartial court to try civilians, since they are not subject to military law.
When they are taking oath, they swear to defend the UPDF Act and not the Constitution like the judges do. The court is composed of soldiers, some who are not lawyers, therefore they are not trained as lawyers, may not have the competence of interpreting the penal laws.
In analyzing Article 119 of the UPDF Act, they indicated that for someone to be subject to the military court, that person should have abetted or aided the military officer as the prime suspect in the matter.
They further found that the military courts are meant to try soldiers of disciplinary cases and matters which are related to operations and not matters which are penal in nature. That is where the cases are defined by the act about the offences that have been committed.
Talking to lawyers following this judgment, they had mixed reactions on court's judgment.
We hope that the executive will respect this court decision, that the DPP will take back the cases as ordered by court.
As if this case has only helped Honorable Kabaziguruka, which is okay, but to me I see more civilians with soldiers being arrested and charged in the court-martial.
Geoffrey Tunyamusima, representing Eddie Sebu Falais Eddie Mutwe, Nubian Lee and other National Unity Platform supporters in the General Court-Martial, welcomed the judgment.
Upon the lapse of the 14 days, we shall be able to trace all our cases and to do whatever it takes to release our clients from several prisons on bail.
Where a civilian commits an offense with a soldier, abetting or aiding, that person should be charged with the court-martial. Now, that renders this judgment almost inapplicable.
Although 7 and similar judgments have been delivered from different courts on the same issue, the court-martial has declined to adhere to these judgments.
It shows a very bad example to civilians, and then they might want to take the law into their own hands.
If they fail to do in accordance with that court judgment, there shall be already a contempt of court order, and we shall go back to the same court.
I do not see anything that is going to harm the court-martial or that is going to harm the UPDF.
Fiona Nabasa-Wall, however, asked Parliament to amend the UPDF Act, as it was elected by court before, to avoid such incidences.
We cannot say that we're in a democracy and the court issues an order that changes the law and Parliament does not effect it.
Lawyers also expressed their views on how they are treated in the court-martial.
When we appear in that court, we are robbed, we appear in robes. Now, by being an enrolled advocate, you must be respected as an advocate.
And the rules there are completely different. And also the jurisdiction of the court is different. The powers of the head of the court-martial is completely different from the powers of a judge.
So the whole system is too unfair. The whole system lacks independence.
The Attorney General vowed to appeal against this judgment.
We are going to study it as the Attorney General's chambers and decide on the next course of action. So we have certain parts of the judgment that we don't agree with, and we need to study them and internalize them and then make a decision on how to proceed.
Those who do not want to be charged in the military courts, the civilians, that appeal will eventually help the civilians if it at all the judges come out independently and follow our constitution.
Court also ordered Kabaziguruka's case to be referred to the High Court for investigations, and all civilians with pending cases in court-martial to be transferred to the civil courts within 14 days.
The Attorney General has a right of appeal against the judgment and orders of the Constitutional Court. In that regard, it is not in order for the DPP to go ahead of the Attorney General.
If the Attorney General fails to appeal against this judgment in the Supreme Court, all orders by the Constitutional Court justices will stand after 14 days. Deborah Namamaonde, UBC News.